All right. Thanks everybody for joining us today, this Friday before Thanksgiving week. Hopefully we've got a good hour of content for you here as we head into the weekend. So my name is Will Burnett. I am a partner in our corporate and transactions group and co-chair of the food and beverage group. And I'm very excited to have my partners, Emily Fox and Chris Lindstrom from our labor and employment groups. Our labor and employment group joining us today to talk about tips for building the right team for your food and bev startup. And so before we get into the content, maybe I'll give you guys an overview of who we are at Nutter and what our food and beverage practice entails. So we really represent all aspects of your growth and your development as a brand, everything from corporate and commercial agreements, distribution and sales broker agreements, support of the IP portfolio to the extent that you have patents, but more likely making sure that you've got defensible trademarks and you're protecting the brand that way, all the way on through to mergers and acquisitions. So really everything from start to finish and everything on in between. We do this for brands across all stages, from folks at the very early stage to folks that have maybe gained more national distribution and have a national foothold, to folks that may be even larger than that and are distributors or investors or supply houses. And so we represent really everybody across the spectrum. Chris, next slide, please. So here's a good representation of who we serve. The team is about 25 or so people across multiple disciplines. Here's some pictures of us when we wore suits in a different time. And that's really it. We're excited to be with you today. To the extent that you have any questions about who we are and what we do, feel free to reach out to any one of us, and I will now turn it over to Emily.
I think I'm going last, Will.
Oh, got it. Sorry, you want to introduce yourself first?
Oh, sure. Yeah, my name is Emily Fox. I'm in the labor, employment, and benefits practice group with Chris here. We represent employers and anything that can come up. And we've been doing a lot of work, COVID-related work. So that's what I'll be presenting on later at the end of the slideshow.
All right, thanks, Emily. So Chris Lindstrom, as Emily said, I'm also in the labor and employment practice group. We wanted to cover some employment issues, some equity issues, and then also the COVID-related issues are obviously front of mind for a lot of people now. As we go through this, it's not as if in an hour we can cover every single issue and give you an answer to every single issue. So we're trying to walk through what, as you're starting to build your teams, what are the issues that you're going to be presented with first? What are the most, the biggest pitfalls to avoid and risks to mitigate? And so, hopefully you can come out of this with the idea that you can spot the issues as they come. As I'm sure all of you know already, Massachusetts has many wonderful qualities, but it doesn't make it easy to hire employees. It's a very employee-friendly state, and therefore, there are a lot of technical issues that you have to be aware of in terms of compensating employees, hiring employees, providing equity to anyone, whether they're employees, advisors, et cetera. And as Emily said, finally, she's going to touch on some COVID-related issues that a lot of our clients have been confronting, and whether that is with respect to having offices or not having offices, you're still presented with a number of issues. So, what I wanted to start out with first from the employment side is the one issue that comes up over and over again, and it's one of the hardest ones to really deal with as you are going from that entity that is you yourself to 2 or 3 people to then 5 or 6 people to beyond. And that is the question of an employee versus independent contractor, because I'm sure in most of your businesses and in your past, you've served as either an employee or an independent contractor, depending on the situation. And the benefits why a lot of folks want to be independent contractors rather than employees are, for the most part, it's tax related. It costs a lot less to have an independent contractor than an employee. And often you will have folks approach you that want to join your team, and they will tell you that they would rather be an independent contractor than an employee. But the issue is that in Massachusetts and in many other states like California and a growing number, it is actually very difficult to be considered an independent contractor in most situations. In order for an individual to be an independent contractor versus an employee, you have to meet all 3 of this, what's called the ABC test. And these are the three sub bullet points I have up here. The individual has to be free from control or direction. So in other words, it has to be a situation where you give an assignment, the person does the assignment and comes back with a completed assignment, rather than constant supervision or kind of a collaborative assignment. Number 2 is often the hardest one, and that the independent contractor has to be providing a service that is outside your usual business as the entity. So in other words, if you are if you're a food and bev company, you may need IT services, to set up your website. That could be an independent contractor because it's kind of outside of what you're doing. But if you're going to hire perhaps a sales force, is more likely than not that sales force will be considered employees rather than independent contractors, because obviously, an important part of your business is getting your product out there through sales. So this is the difficult one for folks to understand, to really figure out and determine in terms of when they hire individuals. The third one is the individual, to be an independent contractor, has to be customarily involved in an independent operation. So, what this usually comes down to is the individual captive to your organization, or can the individual work for a number of different, maybe even your competitors at the same time? In other words, can they operate free and independently as a third party for other services? A couple questions we always get are, what if the independent contractor says, I want to be an independent contractor, and signs a document, a contract that says I am an independent contractor? That's not going to be sufficient. In other words, if the relationship were ever to break down, and the person were to, for instance, sue you for overtime that he or she thought that he or she should have been receiving because he or she was an employee and working more than 40 hours a week, just because they signed that document saying they're an independent contractor, is not dispositive. Another question we always get is, what if the individual, instead of hiring John Smith, you hire John Smith LLC, set up a separate corporate entity? Would that then make the person an independent contractor where they'd otherwise be an employee? And again, the state, both the tax authorities and the state AG's officers will look right through that. And so, what it comes down to is a kind of a risk evaluation. You are going to be confronted with a number of situations where you may want to just keep an independent contractor status for someone, but you just got to be careful that there is a risk, if the relationship sours, that person then could claim after the fact that he or she's an employee and deserves some extra pay. The other issue I wanted to start off with was whether you should, as you're bringing someone on your team, do you need a full-blown, kind of 10-page employment agreement that you may, pull off the web or have from a prior, prior business that you were affiliated with? And I think the answer there is typically no, unless you are dealing with having to give out equity, which Will's going to touch on in 30 seconds. And that's going to be the situation where maybe you're going to want a more fulsome contract. But if I'm you, I would much rather do an offer letter, just kind of a 2-pager, less is more, in terms of setting out salary, job duties, and make sure that there's something in there that says the person's an at-will employee, unless you are being forced to sign a contract to guarantee someone a year's salary. So I want to turn over to Will now to talk a little bit about the use of equity to bring people on the team.
Thanks, Chris. And yeah, you raised a good point that a lot of this, a lot of what we're going to be talking about today comes down to sort of risk appetite and how much are you willing to roll the dice on things that may be close to the line, and what are the risks associated with that. And as Chris mentioned, the rubber tends to meet the road when the relationship sours and terminates for one reason or another on less than ideal terms. And then you're in a situation where had you been thoughtful about it or sort of planned ahead for the souring of that relationship, you could have solved for it. Another situation where we see these issues tend to come up is in an investment or an M&A type of transaction, where you'll need to provide representations and warranties to the buyer or the investor that a certain set of facts happen to be true. And so they don't, those folks don't want to buy or invest into a company that has potential liabilities on its books. So at that point, it might become an issue. Well, so like Chris said, the idea today is just to issue spot for you, so you're aware of these as you're ramping up the business. And one of the areas where folks tend to get things wrong, or there's a large potential to get things wrong, is with respect to equity and issuing equity to the team as it grows. So equity is a tool that allows the holder to participate in the appreciation of the value of the company as it grows and succeeds. And it's a great equalizer because the talent that you're trying to attract probably commands a market salary that you don't have the ability to pay at the moment. And so equity is used to make up that difference by providing the potential for a big return to these early folks as they come in and they take their slug of equity. Next slide, Chris. We're going to talk about how equity comes in different forms and different flavors, but crucial to all aspects of equity, regardless of the type of equity that you're issuing to your employees or independent contractors. It should always be subject to some form of vesting. It's crucial for making sure that your employees are motivated and incentivized to continue providing services and that they're meeting the expectations that you've set for them. So the most typical type of vesting is time-based vesting, which requires the employee or the service provider to remain with the company for an agreed upon length of time in order to get the full benefit of the full equity award, right? You don't want to be in a position where you've given somebody 10% of the company on day one, and on day two, they decide that it's not the right fit for them, and they quit and they leave with that 10% of the company. Terrible situation to be in because, right, you as the founder of the company have been diluted by the issuance of that 10% equity, and now you're gonna have to find a replacement for the individual that's just left, and you're gonna have to issue that person some equity to get them on board. And so it's this sort of downward spiral of dilution that you could have prevented by making sure that the vesting was subject, that the equity was subject to vesting from day one. The most typical structure that you'll see as you bring on employees is what's called a one-year cliff, where 25% of the shares will vest at the first year anniversary of the start of employment. And so the result of that is you've got this sort of one-year test period or grace period where you can see if things work out. And if the employee leaves at any time for any reason, usually during that first year, he or she gets nothing. And then after that, they will have served their time, and then the rest will vest more frequently in periodic installments, usually monthly, sometimes quarterly, and usually over the remaining 3 years. So 4 years total is pretty typical in these situations. Sometimes, depending on who the employee is, it may not make sense to tie it specifically to a particular time frame, and instead you might tie vesting to the achievement of certain milestones. You see this most frequently with the sales guys who should be motivated to actually produce results rather than just spend time with the business. And so sometimes you'll see those tied to sales milestones. Acceleration is a way to make sure that the employee is protected, and it's often the case that either single trigger or double trigger acceleration will be used to make sure that the employee is protected in a situation where he or she is terminated without cause, right? There will have been sort of an opportunity cost for taking the job with you. They've probably maybe turned down other opportunities. And if they get terminated pretty early on and they're left with nothing to show for it, it may not be the most equitable result. So acceleration is a way to make sure that the employee is protected from terminations that they may not have otherwise wanted to participate in. Next slide, Chris, thank you. So the two most common types of equity awards, and regardless of whether you're an LLC or a corporation, we'll use these sort of interchangeably for the time being. We've got either restricted stock or stock options. So restricted stock is an actual grant of stock to the recipient on day one. Typically has the same right as all other shareholders that are on the cap table. And rather than vesting on a forward-looking basis, it's subject to a risk of forfeiture. So if I issue you 10% today, that 10% is yours, but it's subject to a risk of forfeiture. And if you don't stay with the company for 3 years, I'm going to be able to claw back portions of it for the period that you didn't perform services for the company. Restricted stock is taxable upon vesting. Or you can make an election with the IRS to be taxed upfront on the value of the shares. And so the major distinction between restricted stock and stock options is sort of the categorization of the award for sure, but how they're treated for tax purposes. Restricted stock, to the extent that you're issuing stock outright to any employee, the IRS is going to deem that to be consideration, right? It's compensation. It's part of their compensation for performing services, and it's going to be subject to the value of what you're giving them is going to be subject to ordinary income rates. And so at a certain point in the growth of your business, the issuance of those shares is going to be sort of prohibitively expensive for the recipient to receive, right? As we talked about, these awards are meant to incentivize folks. And so hard to incentivize somebody if you give them a thing where immediately they have a large tax liability for having received it and no additional cash to pay that award. So at a certain point in the development of your business, as you reach a certain stage, it probably makes sense that restricted stock will no longer make sense. And instead you'll start to issue stock options to your employees. A stock option is not an outright grant of stock. It's basically a contractual right to buy stock in the future at a price set today. And so the recipient is not an actual stockholder until he or she exercises the option and pays the exercise price for the option. The result of that is sort of a tax neutral event for the recipient, at least upon receipt of the award, and the taxable event gets deferred until the point in time where they've made the affirmative election to exercise that option. There's two types of stock options: non-qualified and incentive stock options. Kind of beyond the scope of this presentation, but stock options tend to be the more common vehicle through which you will incentivize your team for these reasons. Next slide, please, Chris. We'll burn through this one pretty quickly. To the extent that you're an LLC, there's an additional thing that you may be able to give to your employees in lieu of restricted stock or options. It's called a profits interest. It's an interest only in the future profit above and beyond the value that you've joined the enterprise. It's complicated. There's some tax. There's a lot of tax complications with regard to this. And there's the main thing to know about this is there's no corporate equivalent to a profits interest. So to the extent that you have formed the business as an LLC, and there's a strong likelihood at some point in your growth you're going to convert that LLC to a corporation, to the extent that you have issued profits interest along the way, it's going to be hard to convert those to any real equivalent at the corporate level. So that's all I'll say about that. To the extent that anybody has further questions, we can obviously talk about them, but I want to keep things moving here because there's a lot of content to cover. Here is pretty much everything that I just talked about, except in chart form. So that's a handy reference for you, which we'll make this content available to you after the presentation. So I think that's all I've got for the moment, and I will turn it back over to Chris.
Thanks, Will. So beyond providing equity, obviously there's the component of compensation that is the actual salary or hourly wages. And so the key point to take away here is that minimum wage is always required. So you can't only issue stock options or any form of equity in place of salary. You have to, a lot of folks will at least pay minimum wage, and maybe that's all they'll pay, minimum wage, with the upside of all the options or the other equity. But you always have to keep in mind that you have to give some form of cash compensation to employees. And the other aspect is that you can't also agree to defer the compensation. So in other words, you can't say, hey, we don't have the cash now, we'll pay you a year from now. You have to include that payment, at least the minimum wage, on an ongoing basis as the people work. So then the other question always comes up. Well, we have a bunch of people who are willing to volunteer for our company. Often I'll see this in your industry in terms of sales teams going out and running a stand or whatnot. And what I always say is that unless people are family members, or unless you are a nonprofit, there really aren't volunteers out there. They are going to be, there is going to be some expectation if they're providing a service that they should be paid. So, often there will be situations where, you have a friend or whatnot who provides a lot of services, and you always thought it was a volunteer situation, but then all of a sudden you become not so good friends 6 months from now. That person may come and claim that they are owed for the services they provided. So, again, unless it's a close family member, I'd watch out in the volunteer front. So then the other option is interns, and especially unpaid internships, especially where we have a lot of universities and colleges around the area. This is a great source of getting that extra help that you might need without providing compensation. But again, Massachusetts doesn't make it all that easy in terms of unpaid internships. So what I always tell people is go through the schools, because one of the key components in the authorities evaluating whether an internship was actually a proper unpaid internship rather than an employment situation is whether the person is getting credit, school credit for this internship. So that's why it's always best to go through the schools and go through their programs to make sure that the person is getting credit before you start to do an unpaid internship. Even if that person is a student, you want to make sure that there's going to be credit provided.
Hey, Chris, can I tell a quick war story?
Absolutely.
So this gets back to sort of the risk analysis that you'll undertake, and right, being an entrepreneur and the founder of a startup company is all about risk analysis pretty much every single day. And so if you're hiring somebody, or if you're asking somebody to volunteer to man your booth at Expo East for a couple of hours, right? The risk is probably pretty low if you don't pay that person minimum wage. But if you hire an early employee and don't pay that person minimum wage, the risk, increases probably exponentially. We're currently helping a client in the space who very early on in the business hired a team member to perform services. And right, it's not an uncommon story, right? Early on in the formation of the business and before sort of product has hit the market or there's really any revenue being generated from sales, it's hard to find cash to actually pay people. And so this particular client didn't pay minimum wage to this employee for about a year and a half, and everything was fine. Things were, they were working together. Everything was getting along fine. And then the founder of the business found out that this other guy was literally stealing from the business, literally like doing bad acts, stealing from the business, and terminated him. And to Chris's point that he made earlier, he terminated him. The terminated employee consulted with an attorney, and notwithstanding the fact that he was potentially facing criminal liability for theft, he brought a wage claim act against the company for failing to pay him minimum wage for that first year and a half that he was working for the business. And so it's a real thing. It's a real risk. And even if you think that it's unlikely to happen, it really can, and it can happen in the blink of an eye without even expecting it. Even when you think you're doing the right thing by terminating somebody for stealing from the business. So that's all I got. But I'll turn it back over to you, Chris.
Yeah, no, and in the beginning of that, you hit on the exact right point in terms of it's all about risk assessment, and if someone is helping you out for an hour or two, it may not be, you may have some issues, but they're not going to be major issues. But if you are bringing on your new CFO and agreeing on the side that you'll pay him later, that could become an issue. The other issues in terms of compensation, just to be careful of, overtime. It's overtime, whether someone qualifies as exempt for overtime is very technical. And so you just want to make sure that, again, you are paying someone properly, because you don't want the issue to come back 2 years later, or like Will said, if you're at an exit moment, you don't want it to come up in due diligence, and all of a sudden that's this person who may be able to hold up things for you. Commissions and bonuses, you obviously are going to want to use plenty of incentives like commissions for sales and bonuses and other bonuses. Make sure you put them in writing. That's all I can say about that, is that make sure it's in the offer letter in writing, or however you're going to set it up. And make sure that writing says that you're only going to be paid commissions or bonuses while you continue to be an employee. Because I get so many cases where someone leaves, and it could be a situation like Will's saying, where someone is fired for some awful reason, and yet they still claim that when you get this, a big sale come in 6 months later, that they are due commissions on something. So make sure there's language in there that says they're only going to get the commissions as they continue to be the employee. And then the final word of warning, I'll keep piling on. Will already mentioned it earlier, but the real problem here is that if there is a minimum wage or an overtime claim, the individual can claim triple damages and get their attorney's fees. And whenever there's a provision where an attorney can get his fees, you can rest assured that the plaintiff's attorneys are out there thinking, they can make a quick buck by really driving someone to make a claim that they may otherwise, not have thought to pursue on their own. I'll quickly touch on non-competes if you're thinking about them. There's a new law in Massachusetts that makes non-competes a lot harder for employers to use, especially if you don't have a ton of cash sitting around. There are now rules that you have to pay what's called garden leave while someone while someone is sitting on the sidelines if they're honoring a non-compete. So I advise you to really look at whether you can use a customer non-solicitation or employee non-solicitation agreement in combination with a non-disclosure agreement, which I'll get to in a second, in place of a non-compete. Because it really is a question of whether you need a non-compete for anyone beyond kind of your core 1 or 2 people in your business. Like I said, non-disclosure agreements, these are an absolute must to protect your confidential information. I would say those, and then the assignment of inventions agreement are kind of the most most important ones for you to make sure that you have everyone sign. Because the last thing you want is for there to be any question of who owns whatever you're coming up with in terms of your products. Will, I know Will usually gives anything to say on this one.
Yeah, this is right. This is among the most common ways that folks screw things up and make more problems than they need, usually on the eve of an investment or an acquisition. Right, when an investor or a purchaser of a business is investing in or buying the business, they want to make sure that what they're buying is all rights to use the assets and the intellectual property of the business. And to the extent that there's anybody out there in the universe that has a claim or has a potential claim against the IP that's been created by the business, then that's not a great fact and is definitely going to give pause to that investor or that acquirer. So getting these things in place early becomes the key. It's non-controversial, right? And from my perspective, you should just have a packet of documents that you use when you onboard employees all of the time. And that's the offer letter, it's the NDA, and it's the assignment of inventions. And so, right, they're agreeing right up front that anything that they create while working for the company, any IP that they create, any ideas or concepts, if they make a suggestion about how to tinker with the recipe, or to that maybe you should add a new flavor, all of those things, the output of all of that should belong to the company, and it shouldn't belong to any individual, any employee or contractor on an individual basis. And so getting those folks to sign those documents early smooths that path for a clean investment round or a clean acquisition, because the worst thing that you can have is a former employee or a former founder who never signed one of those documents, and then you need to get them to sign it as a condition to that investment money coming in, or as a condition to the acquisition closing, because in that moment, this thing that probably was non-controversial at the start of that person's employment now becomes a great leverage point for them to extract some value that they otherwise are not entitled to. And we saw this happen a couple of years ago on a deal we were working with, where a co-founder didn't sign one, needed to sign one as part of the closing, and was able to negotiate like a 6-figure sum to make it worth his while to sign that document. So could have been avoided had it been signed on the onboarding of that particular employee. So just make sure you're doing that stuff in the ordinary course and not chasing them after the fact.
And the easiest way to do it is just to have your offer letter that references this other agreement that the person's going to sign, and then they sign it at the same time with the offer letter. And the NDA and the inventions assignment, they should be, it's easy to just have one document that covers both topics, which you can do, so that you don't have to have 2 agreements forced to sign. I'll touch on employee handbooks. There are way too many employee handbooks or employee manuals out there. You don't need them. It's much easier to have standalone policies for the things that actually matter, because if you are pulling down, again, if you're pulling down a handbook from the web, or you're pulling down a handbook that you had from a prior company you're affiliated with, there are going to be so many policies and provisions that just don't apply, either because they're outdated or because they don't apply to your business. And last thing you want is for something to be in there that you didn't realize was in there and has no application, other than for some reason it can be turned around against you, a year later when some employee says, you promised me X in the handbook. So there are some policies that are required under the law. For instance, you're required to have a sexual harassment policy. There's some policies I recommend that you have in writing, for instance, the commission's policy that I referenced earlier. But again, no need to spend the money or the time or the aggravation on a handbook. In terms of departing employees, the most important thing here is that if you fire an employee for whatever reason, you have to pay that employee all of their wages due on that final day, or else it's going to be a violation of the Wage Act. So, it's one of those things where I have so many clients who scramble to have to cut a check or do a wire. So try to plan that ahead. That if you're letting someone go, unfortunately, you got to pay them on their last day. The other question that always comes up is severance. Should you provide severance? Should you have a severance policy? Should you always give 2 weeks for every year that someone served the company? And you probably should, if you're terminating someone for no real reason. You give them something just as a soft landing to the extent you have that something. But you don't always, typically people when they pay out severance, they want someone to sign a release. But if you don't sense that there are any issues, if this employee, you don't think the employee is going to bring a lawsuit for discrimination or unpaid wages or whatever it is, often it's better just to pay the severance and not require a release, because those release documents always say, hey, before you sign this employee, you should go consult an attorney. And so they may then decide to consult an attorney when they would not have otherwise. And as soon as you get an attorney involved, that attorney may be looking for issues to bring up, and you could have opened up a can of worms. So often it's better just to pay out the severance and try to leave on good terms without requesting a release. And so then with that, I wanted to turn it over to Emily to kind of cover some of the COVID issues that we're seeing for emerging companies out there these days.
Hi, everybody. There's so much we could talk about with COVID. I'm only going to touch on a few things, but if you have any issues, a lot of people I understand are working remotely right now. If you have any issues with remote working policies or that sort of thing, definitely reach out. What I'm going to talk about is things that you can and can't do in this COVID world as far as welcoming employees back to the office and the federal leave entitlements. So just as kind of background, right now, employers can ask employees quite a lot of questions and require them to do quite a lot of things that they really can't do in normal circumstances, because COVID has been found to constitute what's called a direct threat under the Americans with Disabilities Act. So you're able to ask questions of your employees in order to protect your workforce in the office that you really can't ask in normal circumstances. So a lot of employers are, I'm sure you've heard about temperature screenings and that sort of thing. A lot of employers are doing screening before you come to work. And actually in Massachusetts, you're required to screen workers before they come into the office. And that would even be if your office is technically closed, but you're allowing people to kind of one-off come into the office to do something or another. And in Massachusetts, you have to ask three questions. One is whether the employee is experiencing any COVID symptoms. 2, whether they've had a close contact with a positive COVID-19 case. And the definition varies according to where you get it. But in Massachusetts, it's living in the same household as somebody who has COVID, caring for an individual who's tested positive for COVID, being within 6 feet of someone who has COVID for over 15 minutes, or coming into direct contact with secretions from a COVID positive person, such as getting sneezed on, or being asked to self-isolate or quarantine by a doctor or health official. And a lot of employers, I'm sure you're hearing a lot about this in the news, travel. This came up in the summer quite a bit, and it's going to come up now in the holidays, with different states having different quarantine requirements and travel orders. It's okay for employers to ask, and I would encourage employers to, frankly, to ask about travel to high-risk areas. Massachusetts has a travel order which requires people coming back into the state to either quarantine for 2 weeks or produce a negative COVID test. So they had, your employees have to follow that if they're coming into the office. Confidentiality concerns. Notice when I talked about close contact, you can't ask about employees' family members, whether they have COVID-19. That's under a different federal law, GINA. It's the Genetic Information Act. But you can ask, you have to ask the question artfully. So are you living with someone? Are you caring for an individual? Just remember, you can't ask about your employees' family members' health. And also any screening forms that you do have employees fill out, or apps or something like that, make sure you keep all that information in a file separate from your regular personnel files to maintain confidentiality. Next slide, please. So say you have a positive case at work. We have a lot of smaller employers calling about this. What do I do? The first thing that you want to do is, obviously the employee should go home or should not come into the office if they're at home. But you're going to want to call the local board of health wherever you are and tell them about the positive case of this employee who was in the office. And they're going to help you figure out what to do. Especially with contact tracing, you're going to want to talk to the employee and see who they were around for 48 hours before they became symptomatic or got that positive test. And that employee will need to quarantine. The local board of health will help you figure out what other employees, if that applies, need to quarantine. And even if you have a very small office, there's a few people there, you cannot tell the other employees the identity of the person who tested positive. They may be very easily able to figure it out themselves, but you as an employer cannot share that information. The employee can. They can disclose that themselves, but the employer can't. And then to come back to work, you can require certain things of employees, again, that you probably couldn't in normal times. You can have employees produce a negative COVID test, a doctor's note, a certain period of time without symptoms. And similarly, you can require them to quarantine for the 2-week period. I've had some questions. The employee has a negative COVID test and wants to come back to work. Can I require them to quarantine because of the incubation period? You can. And all those reasons may be eligible for the emergency paid sick leave under the Families First Coronavirus Response Act, which I'll talk about next. The quarantine issue is a little fuzzy. So say your employee's working from home and says, I just traveled from out of state, I need to quarantine, pay me under this federal law. They are only eligible for it if they're unable to work or telework. So in a lot of cases here, the travel order, for example, if you have to quarantine because of a travel order, or you had a close contact with somebody who's positive, but you can telework, then you have to telework. You're not eligible to get paid time if you're able to work. Another thing that may come up in the future as vaccines become available, employers can require employees to get a vaccine, with some big exceptions for disability and religious accommodations. Next slide, please.
Hey, Emily, quick question. Do I have it right that say you have an employee who went out and visited a customer, the day before, and then all of a sudden that employee says, hey, I just got a positive COVID test. You as the employer should notify the customer, but again, you can't say it was Karen. You just have to say, one of our people visited you, and even if Karen was the only one who went to that customer that day, that's okay. But it's just for confidentiality, you just can't identify the name is basically what it comes down to, right?
Right, and in cases like that, it's going to be a formality. They're going to know who it is. If you have, 3 people working in a room together and one's not there the next day, they're going to know it's Bob. But yeah, you just can't identify the person. Exactly. So you're probably familiar somewhat with this, the Family First Coronavirus Response Act. It provides emergency paid sick leave and expanded leave under the Family and Medical Leave Act for certain COVID-related reasons. So the emergency paid sick leave, employees are eligible for up to 80 hours at up to 100% of their rate of pay for certain COVID related reasons, and employers get a dollar for dollar tax credit from for those wages that they paid during the emergency paid sick leave period. There's 6 reasons. Employees will get 100% pay if they're subject to a quarantine order, which can be, it could be a travel order, for example, if they can't telework. It could be the local board of health saying you have to quarantine and they can't telework. And it could be from a healthcare provider if you're a close contact, for example. Or in 100% pay for if you're experiencing symptoms and seeking a diagnosis. So basically, if you're ill with COVID or seeking a diagnosis, that's 100% pay. And then it's 2/3 pay for if you're caring for an individual who's subject to a quarantine order or sick. And then also if you can't work or telework because your child's daycare or school is closed. And that's come up in the back to school context, like hybrid schools, or if you in a hybrid situation, for example, you could get the paid sick leave for the days that your kid's not allowed to go to school, but you can't get it if you choose to keep your child home and not go to school if it is open. One thing we get a lot of questions about is you can't require your employees to use their PTO before using this emergency paid sick leave. You have to allow them to use the 80 hours first, and then they can use their accrued PTO. There's some documentation requirements for this in order to get the tax credit. It's pretty minimal. All employees have to provide is the reason for leave, the dates of the leave, and a statement that they're unable to work because of the leave. If a healthcare provider told them to quarantine, you have to also provide that. And we've also gotten some questions about kind of fraudulent leave, and the FBI has actually recommended that employers call to verify the healthcare provider that they did recommend the quarantine if there's a case where you're suspecting some kind of abuse of the emergency sick leave. Expanded FMLA. So as you know, if you're covered by the FMLA, many of you won't because you're under the number of employees. You get 12 weeks first for certain medical conditions, birth of a child, etc. Under this expanded FMLA, if your child's daycare or school is closed, you can take up to 12 weeks for that reason. There's a small business exemption for the family's first leaves, but it only applies to the child care closure. If your employee's sick or subject to quarantine, one of the other reasons you do have to provide that leave, even if there's no kind of undue burden analysis for the emergency paid sick leave. And this can help the paid benefits if you're telling your employees they have to come home and they can't work. So that's all I got on that.
Great. Thank you, Emily. So we got about 10 minutes left. So happy to take any questions that any of you may have specifically. But maybe before that, just sort of in summation, there's some things to keep in mind as we leave the presentation. From my perspective, with equity, just acknowledge and accept that it is complicated, but it is extremely, extremely important to get it right. And while you might think you're saving dollars by doing it yourself or not having an attorney take a look at it, in the long run, if you get it wrong, and there are a lot of times when I've seen folks get it really wrong, the cost and the time associated with going back to try to fix these things far exceeds the cost and time that it would have taken had it been done properly right out of the gate. And so, I get that folks don't have unlimited budgets, and we work with entrepreneurs and startups across the whole spectrum of the life cycle. So I totally get it. But I always tell folks, the places where you don't want to skimp, the places where it makes sense to consult with an attorney are anything having to do with equity and anything having to do with intellectual property, because just the costs associated with getting it wrong are so extreme and can crater the business, can crater a deal, can crater an investment, and really over nothing. So that's my key takeaway from my piece of this presentation. Chris?
I would just repeat the independent contractor and minimum wage issues. Those are the biggest ones for companies that are building their teams. Because again, it's one of those issues where it seems as though it's a no big deal until it becomes a big deal. So you know, just when someone approaches you and wants to be an advisor or whatever they want to be, and as an independent contractor role, just you know, you just want to be careful to make sure that you know, is this the type of situation where I should really you know, stick to the line and classify the person as an employee. I don't know, Emily, do you have any final thoughts on this or COVID related?
No, I think for the COVID related stuff, I think there's some questions about non-competes to your last point there that we can answer. The COVID stuff, really, I would just call the local board of health. That's my biggest piece of advice. They're gonna help you figure it out, and contacts and stuff like that. But call us if you have any questions about that too.
Yeah, Emily, I do see that we do have a question about non-competes. Do you want to?
Sure.
Yeah,
the question is, what about non-competes for a seller in an acquisition to protect the buyer? Chris mentioned the non-compete statute. It covers non-competes arising out of an employment agreement. Non-competes that arise out of the sale of a business do not fall under the statute. So as Chris mentioned, there's a ton of requirements in Massachusetts that make it really hard for an employer to impose a non-compete, but a non-compete in a sale of the business doesn't have to comply with those. They can be longer and broader than an employment-related non-compete.
Yeah, you know, it's typical, and also it's fairly easy to enforce a non-compete in that type of situation, because as the buyer, you're buying a business that has been created, you know, and established and developed by the prior owner, and for the prior owner to then go and on day one compete may defeat the entire purpose of the acquisition. So.
Yeah, I concur in these. You know, I think you would expect that there would be a more extensive non-compete in connection with the sale of the business. The question for Chris and Emily here, to the extent that in connection with a sale of the business, the founders each receive employment agreements with the acquirer. So right, they've bought the business, and the founders are staying on to be employees of the acquirer. What would a court look at there if the non-compete that they signed in connection with their employment post transaction was sort of more stringent than what Massachusetts would otherwise allow? Are we looking at employee context, or would it be sale of the business context?
To me, if the individual signing it when they become an employee, then if they're going to look, the court's going to look at it from an employer-employee situation. So it could be one of those circumstances where you're going to have kind of two non-competes. You're going to have the non-compete in connection with the sale, you know, which may have a year tail or 2 year tail, whatever it would be. But then once the person signs on as an employee and signs the non-compete as an employee, that's going to have to it's actually going to have to comply with the non-compete act, and therefore can only be a year and has to have certain other provisions.
So you could, yeah, but the sale of the business non-compete could be more than a year. It could be, say, 4 years. So if if the employee leaves in that 4 year time, they're still subject to that the sale agreement non-compete. It would only kind of kick in if it was after the sale non-compete, say after 4 years, and then the employee left 6 years later. You'd still get that year. from the employment agreement non-compete.
Yep. Good answer. Question about assignment of inventions and what they are and what they're intended to cover. And so the way I think about it is intellectual property is a much broader term than you may think that it is. And so IP includes obvious things like patents and trademarks, but it also includes trade secrets and proprietary information, and really any business information related, to the operation of the company. And so the assignment of inventions agreement is meant to capture all of that stuff, and it should be broadly defined in order to do so. And the idea is any output that you create as an employee of the business or as a consultant or whatever your service relationship is with the business, any output of that service belongs to the company, right? You're being paid, you're being compensated in some form or fashion, whether cash or equity or a combination of both, to perform a service, and the output of that service belongs to the company. So the assignment is just the affirmative act of transferring that work product from yourself as the service provider to the company, and an acknowledgement that you retain no rights in it whatsoever, and that it belongs solely and exclusively to the company. So as I mentioned, they're usually non-controversial, like hard to argue with the justification and the reasons for asking employees to sign it. If you're onboarding an employee and they refuse to sign an assignment of inventions, it's probably a good sign that you shouldn't hire that employee because there's something up there, right? So everybody should sign one. All right. No problem. Happy to explain that. And then I think that's all we got. We're just about out of time. Thank you all for attending. I think as a virtue of having signed up for this presentation, you are now on the Nutter Food and Bev mailing list. So you'll be informed and in the know about all future events as we plan them and have them. So we look forward to seeing you at our next event. And Chris and Emily, thanks for joining me today. And everybody enjoy the weekend and have a great Thanksgiving week.
Thanks, everybody.
Bye-bye. Happy holidays.